child under the legislation. Now, we're assuming that that is considered, but it's not expressly stated. And we thought that that was a simple fix to be stated in the legislation.
Mr. Chairman, sorry, I just wanted to state the provision. Sorry to.
Section.
The request is
for me to state the provision, to reference the provision.
Sorry for the interruption, but you can't.
So, Section 5(1) in the Citizenship Act, and then the Family Law Act, Cap 214, the reference would be Section 43. So we have Section 43 in the Family Law Act stating that decisions should be in the best interest of a child, and we're suggesting that the amendment could be made to Section 5(1) of the Citizenship Act to include the express statement. And before I hand over to Mr. Clark, I'll just highlight, we also flagged the specific issues that plague the sporting sector, where athletes of Barbadian descent have been locked out of international competition due to unresolved documentation. And we believe that it's timely this be considered as you are looking at the bill to understand the practicalities that have impacted the sporting sector. So I'll segue to Mr. Clark.
Thank you, Madam Executive Director. My name is Glenn Clark, council member of the Barbados Employers Confederation. And I also happen to be general manager of the Barbados Olympic Association and a member of the FIBA International Basketball Federation, where I hold several, setting several capacities. Now, the members of the sporting community join with the BEC in supporting these bills, which we believe are long overdue. The sporting, as I said, the sporting community supports the Confederation's recommendation to streamline citizenship and national verification processes for athletes of Barbadian descent and expedited pathways for sporting representation in regional and international competitions. As I mentioned, as a FIBA official and commissioner, I've had the opportunity to review and approve athlete registration at many levels of many competitions over the years. And I've seen how countries use similar initiatives to bolster their teams and through citizenship by descent and naturalization. One just has to follow the Football World Cup to see how this has affected the global sporting community with the composition of the so-called championship favorites. Our basketball team, our national basketball team, in a week will be heading to Guyana to compete at the first level of the Olympic qualification, which is the FIBA Americas. And they will already be at a disadvantage, as many of our regional colleagues will be fielding teams that bear little resemblance to their local leagues, where our national team would be limited to those who are who have national citizens. I give two examples. One of our local squash icons, who would have won many squash titles regionally, internationally in her heyday, was unable to represent Barbados at the multi-sport games. This is where we compete: CSC Games, Commonwealth Sport, Pan Am Games, and the Olympic Games. She has gained citizenship, but we could have benefited with many more medals if she had the opportunity to represent Barbados when she was younger. Another example is in 2014, our national rugby team qualified for the Commonwealth Games, but many of the teams, the players on the team, did not hold passports of the country, but had lineage where their grandparents and great-grandparents were citizens and nationals of Barbados. As a result, we had to compete with a team who have lesser talent and skill. At the BOA, we have already started discussions with the Ministry of Foreign Affairs and the Consulate in Canada and the High Commission in London to leverage engagement with our diaspora. And we believe that there are many benefits to be derived from these alliances. And in summary, as a sporting community, we believe that these bills provide a game-changing opportunity for sport in Barbados by having the opportunity to expand our talent base as a small nation, where knowledge and skills transfer from our internationally experienced athletes will benefit our locals. It helps to remove the eligibility barriers, which give our diaspora and the players who have lineage the ability to join our teams and compete at an international level. And I believe it will help us to strengthen our international competitiveness when we face international competition. And again, it helps to leverage the diaspora as a strategic advantage to assist us. We believe that the overall impact for this will be a stronger, more competitive and globally connected sporting sector that contributes meaningfully to national development. With that, I thank you, and I hand back over to our Executive Director.
Well, Chair, we gave a pretty comprehensive written submission. I believe it might have been about 8 pages long. And with those comments, we are in your hands for any follow-up questions.
Thank you very much, and indeed, not just me, but the committee appreciates your submission. They're indeed comprehensive. And again, I want to thank you on behalf of the business community, sporting community, for taking time out to make your oral presentation as concise as you did this morning. And indeed, we have a reference that we can begin now to have a meaningful discussion. But I'm going to take the opportunity to ask the members of the committee to so intervene at this stage, because I know the minister would want to have a say on matters, areas of sports, and some other matters of the Immigration Act to limit the ministerial power. We would have discussed this over the past 2 sittings, and I will begin by saying, you know, and I think I heard Minister Springer, Minister Husbands, and the 3 ministers, 4 ministers, Senior Minister Sinclair, and Minister Weir, the whole aspect of national security. This is so critical because there's so much information that ministers and the cabinet will not want to share with the public. So sometimes you have to just give the minister the latitude and leave it in his hands, know that they will do things in the best interest of the country. And when it comes to national security, those meetings are closed-door meetings. Those meetings don't even include members of the cabinet, some members of the cabinet, Attorney General, Prime Minister, and I think they're limited to police and those persons who are on the Security Council. They're closed-doors meetings. So I just wanted to begin there before I hand over to the members, and I know you understand, Mr. Clark and Miss, I keep forgetting the name. Yeah, Sheena. I don't want to say Sheena. Mears Granville, yes, Mears Granville. But I know her personally, so I don't want to refer to you as Sheena here, Ms. Granville, Mears Granville. But I will open the floor, like I said, to the members who wish to comment on your indeed detailed presentation. So over to the members.
Chair, do you want me to respond to your comment on the ministerial discretion? Or
you can, or you can wait. I have 2 ministers in the room. I was once there. I won't want to speak on behalf of the ministers, but I was. If you want to respond, feel free to respond now, because I know they will have something to say on that matter.
Well, Chair, you mentioned national security, and we're very cognizant of that. In the matter of the bill, it's not that we are trying to circumvent any national security concerns. It is that And we do understand that ministerial discretion is something that we see within legislation. What we're asking for is that the reason for refusal be given and that there is a process for review of that decision if necessary. And the reason why we highlighted that is because we do have a constitutional responsibility to ensure that persons have that right. So it's to ensure that in the bill itself, we don't create an unintended conflict with our Constitution. So that's why the matter was raised.
Just to respond, sorry, Chair.
Let
okay.
Mr. Malu wanted to go first. So you're fine? Okay, you want to respond?
No, I only respond. I'm only responding because I would have responded to the matter when it was raised at the last sitting. Because even in your response, the answer is there. The reason is national security. And that could be the very reason that the minister has stated for not giving a detailed reason. And unless you want something more than that, because I can tell you the reason that I'm not going to discuss this in the public domain, the reason I'm not going to give you a reason for rejecting is because the matter is one of national security that may impact other persons, other players, other parties, other than the individual that is referring to. And would you be satisfied if that was the given reason? Because it wouldn't change anything. You wouldn't know for sure, but yet you know that the reason that you're not being told, or the reason that explanation wasn't given, was that the matter is beyond you. Will you be satisfied with that? Just that, the answer being because it's a matter of national security.
Well, just to be clear, the Act does not specify national security. It says that no reason shall be given. And therefore, if the denial was not a matter of national security, but for some other reason, what harm is it to inform the person that this is a reason for your denial, and it may be something that can then be reviewed and may have a different outcome? So, as I'm saying, we're not saying that national security is unimportant. Of course it is. But the way how the legislation is written, there shall be no reason given. So that includes national security or anything else as a reason for denial.
You're going back at it again?
No. I wasn't responding. I take your point. I guess those from CPC will have to give reason for the language as the way they would say there shall be no reason.
CPC, Mrs. Zeeland, welcome.
Thank you, Chair. Actually, it is a matter of policy. If it's decided there's a change in policy, usually immigration matters, traditionally, no reasons were given. Generally on the basis of national security, but we're in a different age now. There might be reasons, for example, procedural reasons. If the person just did not follow the correct procedure, so the application was discounted, that one may wish to give a reason, just to assist the person, but it would be a matter of policy. If the ministry is desirous of having areas where reasons can be given and areas where they would refrain from giving a reason, then we can amend the draft accordingly. Dr. Springer, you mentioned that a reason can be national security. Would government even want to go that far to say that national security is the reason? Because to my mind, that in itself alerts the recipient of the information. It provides information if that were a reason.
That's the point. That's the point I wanted to make. But at the end of the day, saying is a national security issue is given a reason that you really don't want persons to know. So you just leave it open-ended in that situation, in that case, sorry. But I will leave the floor to the other members because I know the minister will come in at some point in time, but the other members may want to comment on some other matters that were raised. So over to Senator Malago.
Thank you, Chair. Just a brief comment on that. I think that we've had a number of presentations that have raised the same point, and I think it has been well ventilated that the minister does need to have discretion to simply deny. To go further than that can open a can of worms that is unintentional. So I don't want to delve into there. There are people in here more knowledgeable than me that can comment on that. What I would like to ask is directly to Mr. Clark. I must say that I had not in any way considered the impact that this could have on sports. I myself am the president of a national federation, being the Barbados Motoring Federation, and we have very strict rules under who we can grant licenses to for participation in motorsport globally. And I had not in any way thought of that. So I thank you for that little nuance there. And it got me to thinking to ask you the question, is there anything that in this, does the IOC go further in scrutinizing citizenship or eligibility for national teams beyond the passport that they hold? And my question is, do they at every point ask, how did you come to hold that passport? I believe I'm aware, I'm not an expert, that they do have a rule within the IOC that prevents someone from representing a second country within 3 years of representing the first country. So you can't just swap nationalities, even if you hold multiple passports legitimately. But my question to you, sir, is does the IOC, in looking at this from a sport point of view, look through the nationality to find how did you come to hold that? Thank you.
Thank you for the question, Senator. And as you imagine, there are many national federations that make up the IOC, and each national federation has their own policy regarding citizenship and being able to represent their country. The IOC gives each international federation a latitude to set their own criteria regarding national representation. When it comes to multi-sport, all the IOC acts, and when it comes to multi-sport, each one comes under the IOC umbrella, and they ask that each participant or persons who represent the country as an athlete must hold the passport of the country. To your specific question, they do not ask how the person has come to receive their citizenship. You know, if I could go on to give you an example for the sport that I represent at the international level, FIBA. They have asked that, again, that you hold, they follow the IOC, you must hold the passport of the country. What they have been doing over the last few years to make sure that the playing field is almost level is if you are a junior, you must have represented the country as a junior before age 16 or registered as that athlete before age 16. Not wanting to mention that if you're watching like football, for example, you'd recognize just recently France and I think it was Senegal. And if you looked at the French team, you'd recognize that some of the members of the French team looked a lot like the members of the Senegal team, you know, without going on to say much more than that. So what a lot of these countries, big countries, especially those in Europe, have been going into Africa and offering citizenship to the youth before they become young adults like age 16, bringing them in and registering them. You know, for small countries like Barbados, as a small nation, we cannot compete, and we are asked to compete at the global level. You know, we have many, our football teams have been severely criticized over the years. You can imagine every time there's a competition. But our locals are playing against teams that have been able to pull from their diaspora, you know, who are playing in many leagues over throughout Europe, in the US, and so on. And that's who our teams are forced to compete against. You know, so these bills give us some level, it's kind of help us to be competitive internationally. And that's why we give support to the bill. I hope that has been able to answer your question, Senator.
I just want to add 2 comments to indicate that our submission suggested that you consider expedited pathways, and we thought that could potentially look at explicitly stating international sporting representation in the points criteria in the schedule, but also potentially looking at a statutory decision timeline where applications are certified by the Ministry of Sport or any national federation if they're tied to a competition deadline. That is something that you can consider for the bill.
Thank you very much. Mr. Walters, Senator Walters.
Thank you, Chair. Good morning. The conversation around the Citizenship and Immigration Bill has centered around productivity, labor, skills deficit, population size, or population growth, or in this case, stagnation. What is your view? I see your first recommendation, so I just want you to elaborate on it, but your first recommendation is to ensure explicit alignment between the bills and the Barbados Population Policy 2023-2024. On previous occasions, in the committee, I've also asked for the government to provide kind of more detailed reports on skills deficits, where they see the gaps in labor shortages, etc., so that it can be examined in a more prudent way. I see that you're asking for specific alignment between the bills and labor. What is your view in terms of skills shortages, labor, and how is it impacting employers? And do you see this bill as being effective in addressing some of those issues?
Thank you very much for the question. It's always a good deal when I get to talk about skills. And I will say that employers have felt the impact of skills deficits within Barbados. There are some sectors who repeatedly have indicated they do experience shortages when trying to recruit specific skills. And therefore, they are reliant on bringing in skills into the island. Manufacturing is one sector that immediately comes to mind, and we see how manufacturing has been transforming and continues to transform in terms of increased use of robotics, etc., within the manufacturing process. And therefore, there's a need to have highly specialized persons if we want to drive growth in some of our sectors. Now, the data on skills is something that is ongoing. And I am aware that we do have an agreement with the ILO looking through our Decent Work Country program, looking at our skills database and skills mismatching and how we can effectively or more effectively marry the training and education system to the future needs of business. But I will say part of the problem there lies in the structure of our economy. We have more than 70% of our businesses are micro and small enterprises. Not exactly the persons who are going to be able to spend the time to sit down and think about what skills do I need in the next 10 or 15 years, right? So we do need that data, and having the data on what skills are anticipated skills that we need in the next 10 to 15 years to grow our economy would be critical and would then feed into bills such as this, where you're looking at a point system based on skill, etc. And having that information would allow for better coherence between the needs of Barbados and population, and marrying that with when you're analyzing the skills and the point system that you have created under the bill.
Only yesterday, I saw in a local newspaper applications for work permits for a warehouse assistant, a sales associate, and a shop supervisor. So the question I have is that when we speak about skills deficits, opportunities, generally for employment, how are we managing our current system even before we introduce a system where we're actually bringing fresh labor in? What are your comments on those work permits, those specific jobs that clearly locals, if we can't fill those jobs, something is wrong with our education system, our economy, everything.
Senator, I will state that I've been assured by officials from the Immigration Department that, and this would have occurred, I believe, last May when we had a discussion around work permits and CARICOM skill certificates, etc., that when it comes to the work permit regime, that they do follow their due diligence in terms of reviewing applications and either granting or denying. So I leave that squarely in the hands of the officials who have to administer that system. But you mentioned warehouse clerk, and one would think those are skills that can be found on the island. But what about, as I said, someone who specializes in robotics? That skill may not be something that is readily found on the island. A few years ago, I then learned that a dispensing optician was not something easily or readily found on the island. So there are some skill sets that we do have deficits, and that is where we lean into either the CARICOM skill certificate regime or the work permit regime, and which we would address under these new legislation as well.
But I too would wish to support Senator Walters because I strongly believe that there's some skills because of the massive training program that we have undertaken as a government, whether through vocational training, through whatever training. Those are some of the skills. When I see the ads as well, I mean, I'm part of government, but when I see the ads as well, I too, it raises a concern whether we truly have exhausted all of our options locally, and I'm not even talking about regionally. I'm speaking about locally, because I believe if I walk through certain neighborhoods, I can find persons who can do those warehouse jobs. What else you said? Because I didn't see the paper. Sales. Persons who are trained, persons who are in the shoe store. These are persons who walk into our offices daily and ask questions. While I don't want to put the minister and his chief immigration officer on the spot, I'm here to be very fair. I'm not here to be partisan, but I'm here to ensure that we get the best from the public to inform these two bills. So I think I have a duty to the citizens of this country to express a concern when a concern is to be expressed. And I share your view, Senator Walters, in this area that we need to look deeper and reach out to associations like yours when we have these vacancies, because I'm sure persons are saying the same thing that we are saying this morning, and I don't want us to be guilty of saying that we can't find these skills in this country, right? Because Barbadians have a right to employment in this country, everyone. But I'm saying the locals, you look locally first and then you can look regionally. But I can't tell businesses how to run their business. I was once a private sector employee and a part of management, and I understand that there are some things that you have to do, but then I believe too that there are some things that you must do to empower your own. All right, so I just wanted to...
Chair, I just want to add that, Senator, you asked about statistics and information feeding into the system, and I am aware that the Ministry of Labor, through their jobs registry, the intent is to use that information to help advise in terms of where we are seeing those vacancies pop up and to help with the recruitment for those vacancies, but also to then provide information in terms of what types of vacancies exist and where the skills are needed as well. So hopefully, as we have more labor market information systems come on stream, then that data and that information can be used to inform some of these decisions.
Thank you. A question that just came to mind is, with all the current legislation in place in terms of movement of people in the region, how has that impacted on employers' ability to fill vacancies, or how has that impacted on our skills deficit as identified by the government and yourself today? Have we seen a positive impact with some of the recent legislation that has allowed persons to move through the Caribbean and to Barbados and work?
Senator, if you...
I'm not trying to drill you, just want to get some clarity.
That's okay. If you are referring to the change that occurred in October last year, where we have full free movement within the 4 countries, St. Vincent, Barbados, Dominica, and Belize, my members have not reported any dramatic change in the labor market arising from that recent change. I've not heard of any major changes to our ability to have skills available to employers coming out of that.
We're going to have the Chief Immigration Officer who will intervene at this stage.
Good morning, Margaret Ennis, Chief Immigration Officer. Between the 1st of October and the end of May this year, we had about 1,696 persons coming through from the 3 member states under the full free movement agreement. About just over 700 persons registered with the Ministry of Labor. So that does say that approximately half of those persons are persons who basically are indicating that they have skill sets that they'd like to use in Barbados. On the other hand, let's not fool ourselves. There are persons who want their persons to work, so they design whatever they design to say, this is the person that I want to work with me. And the Immigration Department, we are fully involved in that if you submit an application and you are denying a Barbadian or a CARICOM person, we will ask to see the applications and the rationale for denying the person. We'll also ask to see that person's experience and qualifications so that we know when a decision is taken that it is a decision that's basically we've examined all of the criteria and what is required. Not every person who advertises either will necessarily get a work permit. But I'm glad that you brought those points up. I'm sure Minister will speak soon about the fact that we are looking to tighten up in some areas to ensure that Barbadians and CARICOM nationals continue to get equal opportunity for employment, but we've also noticed the decline in skill sets. And so we are looking at every which end because some of the investors are Barbadians and they too are applying for persons to be a part of their establishment so that they can be successful.
We don't want to flip the script and have you on the witness stand. That's not the purpose of the committee. You're feeding into two very important bills, but I recognize your sincerity and the ability to respond when asked, but I don't want it to appear as though we have you on the witness stand this morning. You have us on the witness stand, not we have you. But thank you. I'll ask the minister, based on the intervention made by the Chief Immigration Officer to come in at this time.
Thank you, Mr. Chairman. Let me begin by saying good morning to everyone. I was happy to receive the sight of the submissions from the Barbados Employers Confederation and their concerns. So permit me to just respond just very briefly to some of the concerns. The first one concerning the exercise of the ministerial discretion as it relates to the deprivation of citizenship under Section 13, I believe, of the legislation, or any decision as it relates to the grant or refusal of an application under the Act. The minister's decision shall be final. Now, this is in keeping with the scheme of the legislation that currently exists. This is not a new provision. The grant and refusal of citizenship is a serious matter. And one of the things that we don't see in the legislation is the way in which our legislation is drafted within a context, a broader context. All legislation is drafted. Sometimes you hear the CPC and other drafters speak about the Carroll-Turner principle, which basically means that the references in legislation to the minister is not the person, but the minister is the overall head responsible to Parliament for the actions taken within the ministry and the departments that operate under that ministry. And that really requires or provides a responsibility to take advice from the ministry and the departments, subject to the overall determination by the cabinet. So this is not a personal or individual discretion being exercised, or a discretion being exercised outside of the law or the whim and fancy of a minister. That continues to be the drafting style that we have adopted for many, many years. But the principle, the Carroll-Turner principle, in which the minister acts on the advice of the ministry, subject to the determination, final determination of the cabinet, which is the highest decision-making body in the country, as settled in the Constitution, doesn't necessarily have to be repeated in every piece of legislation. But nowadays, we are hearing the constant criticism that the minister has too much power. Now, the minister cannot act outside of the broad context of the legislation. Each piece of legislation has a legislative purpose that is settled in the long title to the bill and in the actual provisions of the bill. So if a minister is acting contrary to the spirit and purpose of the legislation, then there is no lawful basis for the minister's actions. That doesn't have to be settled in every piece of legislation, because that is also understood. So you don't want in the times that we live in to prescribe the basis on which the minister's actions can be circumscribed. National security comes up, but there are other circumstances that might require ministerial level discretion. And I'm going to use one that has not come up under my tenure as minister. But let's say that there is a military coup or some uprising in another country, and the head of states is in danger and have to come to Barbados without a passport or something like that, or can't go back to their homeland. We're not part of the International Convention on Refugees, and some ministerial discretion will be made. But that's a far-fetched example. I'm just saying that is one, and I deliberately chose it because I don't want to speak to the things that I have to consider as a minister responsible for immigration. The reason why I can't say them is because you disclose your sources and your methods. And the era in which we live in, that is very dangerous, and that's something that I'm not prepared to do. It is also not the business, if I may dare say so, and it may sound strange coming from me who was a lawyer, it is not even the business of the court. No judge, in my respectful view, should have the right to determine national security considerations. It is not something that two lawyers on opposite sides can argue to the satisfaction of any judge. Because the judge is not the person responsible for getting it wrong when the country's security is at risk. What a court can do by way of the level of intensity of judicial review is to determine whether or not the proportionate actions of the state warrant any deprivation of rights under the Constitution or any rights in law. So it's a question of the level or the intensity of review of the court. But the ultimate decision as to the grant or refusal of citizenship on the wide grounds available to the state is an executive action and not a judicial one. And that is not something that is unique to Barbados. No courts nowhere in the world determine citizenship. You don't apply to a court for citizenship because the state didn't grant it and the judge determines it. Whether it's the High Court, the Supreme Court, the Court of Appeal, or the highest court in any land. And that is not unique to Barbados. So what we're doing here is not wrong or out of step with anyone else. If I may just also quickly respond to the concern regarding, but I do agree that we can examine the basis of that exercise of that discretion, because certainly, and I think CBC can back me up here. If, for example, I were to deprive Senator Walters of his citizenship for the specific purpose of disqualifying him from being a candidate in the election, not that I would want to do that for Senator Walters because he hasn't really met much success. But if I were to go to that extreme example to do that, certainly that would not be an exercise of the ministerial power contemplated by the legislation. And the court would strike that down. In other words, the courts understand when the courts respect all lawful actions taken by the executive within their lawful powers. And the executive respects the court's rights to say what the lawful extent of the minister's powers is. That is how we operate on the basis of the rule of law. But you wouldn't have to state that in every piece of legislation because the operating provision of the rule of law guides constitutional action. So we don't have to put that in detail in every piece of legislation. So, second point that was raised, I took a note of here, was the question of the best interest of the child. I applaud the noble way in which the submission was made, but I dare say that I think that the submission might be taken or be made a little bit out of context. Section 43, and I don't agree that there is a misalignment of the powers in the bill and the legislation. The Confederation draws the committee's attention to the conflict identified between Section 5 of the Citizenship Act and the Family Law Act. That is stated in the submission. Now, the two things don't speak to the same thing. The provision in Section 5(1) of the Citizenship Act speaks, I may go to it here now, to the registration of minors. The minister may cause the minor child of any citizen of Barbados to be registered as a citizen of Barbados upon application made in the prescribed form by a parent or guardian of the child. This is the act of registration. Registering a child who is a citizen of Barbados as a citizen of Barbados. Registering a child as a citizen of Barbados on the basis that the parent is a citizen of Barbados. There is no need at that point in time to determine the question of what is in the best interest of the child. because it is a question of a parent registering a child as a citizen of Barbados. Now, the only way that can actually happen is if the child is present in Barbados and the child is presented and all the relevant documentation is presented at the immigration department. So if you have a child that is not present in Barbados and no documentation and the child is not presented, there's no basis of which the immigration department can act because there's no evidence to suggest that there is a child existing corresponding to the documentation that is there. So this provision does not require the immigration department to take in any of the issues into consideration that exists in Section 43 of the Family Law Act. Section 43 of the Family Law Act speaks to the power of a court in custodial proceedings. So in proceedings in respect of the guardianship or custody or access to children of a marriage or a union, the court shall regard the welfare of the child as the first and paramount consideration. That is essentially a different kettle of fish as to the actual registration of the child as a Barbadian citizen. Where the welfare of the child does not, I don't want people to misunderstand what I'm saying or misquote me. It doesn't matter there. Not to say that it's not important, but it doesn't matter for the mere fact of registration. So so the issues such as guardianship, where it is contested, where the child's parents might not be fit, or the parents may be dead or overseas, and somebody is purporting to make an application to the court, I want to be the guardian of this child, or I want to have custody of this child. That is an issue where the court operates on the basis of a principle that the interests of the child matter. On the question of the registration of a child who is the child of a Barbadian citizen and the application to register him as a Barbadian citizen, the question as to the welfare of the child will not come into consideration because registration in of itself will not affect the interests of the child in that specific way. So I just thought I would just raise the question about there was a point about the revised treaty of Chaguanas, denial of all right. I wasn't sure if I expect. All right.
You're looking at point 3, amend 4.3.
Yes, amend 4.3. Okay, let me just take a quick look at that because it wasn't right. That was one that the section wasn't quoted. So section 4.3 of the immigration bill or the citizenship bill, the immigration bill?
This is the Immigration Act. Under the Immigration Act, it states the persons who are allowed to enter, and that is Barbadian citizens and permanent residents. And the section then goes on to say the minister can deny entry. Following that section, we then read of CARICOM persons being able to enter Barbados. So the submission was indicating that under permitted entrance, where it says subject to this act and the CARICOM community, that we have a qualifier there that there would be permitted entry consistent with the CARICOM community and movement.
Yeah, but as long as we are not infringing our community law obligations at the level of the treaty, because those are binding on the state of Barbados. Barbados has signed the treaty, the revised treaty of Chaguanas, and we have community law obligations, and the court that interprets the treaty as the Caribbean Court of Justice in its original jurisdiction has clearly settled in the Shanique Murray case the exemptions to which the right of a definite entry can be refused. As Minister responsible for immigration, I will exercise that discretion on the advice of the chief immigration officer and the officers working in that department to CARICOM nationals who appear to the department and to me as minister that permitting their entry would not be in the best interest of Barbados. And that is permissible within the treaty as a basis for which the state can exercise that discretion. And I've had to do it, and I will continue to do it as long as the information, they would tell you that I just don't sign deportation orders or refusal orders. I go through each and every one at any hour of the night when they call. And sometimes a judgment call has to be made on these things based on information from sources which I will not here disclose. But that is not something that I think that the state should cede to the treaty. The treaty does provide for exemptions to be made on the basis of the determination of the state actor, and that is what this provision is intended to continue. I compliment your colleague for the sorry, if you want to answer that specifically, reply. Go ahead.
Not to that specifically. I wanted to go back to your response on the Family Law Act, and I recognize there was an error in my reference. So you were quite right in highlighting Section 5.1, which has to do with the registration of a minor. What the correct reference would have been 5.2. The minister may, in such special circumstances as he thinks fit, cause any minor to be registered as a citizen of Barbados. So not that it does not cover, and I think I would have said in my initial presentation that we have the assumption, but that it could be strengthened by an explicit statement in the best interest of the child.
I hear you. It's something that I think that we will take a look at, but my instinctive response there is that you sometimes, and CPC, I might be calling you to back me up here, sometimes these provisions need to be written in as general a way as possible. And when you borrow language or phrases that are applied regularly in other pieces of legislation, you open yourself up to the argument as to whether or not the legislative intent is the same. And because the legislative intent of that section which is used in the Family Law Act is done in custody and guardianship applications, the considerations for the court in making a determination on an application that is being fought by two adversarial parties represented by lawyers will not be the same considerations for the minister on a question of the registration as a person, a child as a Barbadian citizenship, as a Barbadian citizen. So therefore, while I understand why that consideration by the court has to be paramount, and while I'm not saying it is not a consideration for the minister, use of the language may give the unintended consequence of it being the same and having the same predominance, while that itself might not be the only consideration for the minister to register somebody who's applying as a citizen of Barbados who is registering a child. Okay? So there are broader considerations there. I mean, obviously our international obligations under the International Convention on the Rights of the Child would predominate there. That has nothing to do with the same things that a court would determine in a family law application. So the minister must understand the state's obligations given in international law to that treaty. But if I were to take the language from the Family Law Act dealing with guardianship and custody and put it there, it would give a different flavor and is subject to argument by lawyers. You know what lawyers are arguing? Right? And then the real broad scope of that provision is going to be limited by use of language in another act dealing with a specific thing. So that is why drafters draft in general language. But I understand what you're saying there. sorry, I just wanted to say, Glenn, thanks for plugging in for sportsmen. One of the reasons why I am very anxious to get this legislation passed is to make sure that we can strengthen our national teams. We would have won a world championship medal in can't remember the name of the sport. The sport is world champion, it's hurling or something like that. The athlete with the world championships this year, gold medal. She wants to represent Barbados. This is the place of her grandparents' birth. But under the legislation, it would be a real stretch if I were to exercise my discretion on the basis that she comes here for a couple of weeks. Can't do that under the law. But I really would want to give our Barbados Olympic athletes and the Carifta athletes and all the other sporting teams the opportunity to dig into the wider pool of talent that is available. So I'm glad that this legislation extends to Barbadians within the diaspora to be part of truly Barbados. I have cousins who were born in the United States of America. My eldest brother was born in the UK. But my cousins in Barbados, sorry, New York, when I went there to the UN Forum on Migration 2 months ago, they startled me because they appear to know as much about Barbados as every person that I talked to in Barbados. And they consider themselves Barbados. They bring their church groups and stuff to Barbados regularly, but they are Bajan, born in New York. Mother and father in Barbados, born in Barbados. But they consider themselves Barbadians, and they would want their children to be Bajan. So this law or the bill that we are proposing here will give the diaspora that comfort and that connection is maintained, because Barbadian culture can only be defended and embraced if the full diaspora has a connection to its commitment and purpose. And that is what we're trying to do here. Right, as Chief Immigration Officer said, it is for that same reason that you are able to use the Section 5 to the exceptional cases and circumstances to give the minister that discretion. There's a child of a famous Olympic athlete. You know, how do we get that child to be running for Barbados as he should be? We got to pass this law, and we can get that gold medal. Thank you, Mr. Chair.
Thank you, Minister. Thank you very much, Chief Immigration Officer as well. I see the communication between the BEC and yourself, and I'm happy. I'm hoping that you both are happy with the explanations given this morning, because you have a very important segment of our national development that you have to respond to. And I know they're listening. But I'll ask CPC who wants to come in at this stage. You wanted to come in? Oh. So.
Thank you, Chair. Minister had asked that I back him up, so I will agree, yes. I do think that the provision should remain general, but when I heard the point made and the connection sought to be made with the Family Law Act, I wondered whether the BEC was suggesting that whether or not a child has citizenship is something that should be debated. In other words, whether the question of whether it's in the best interest of the child to have Barbados citizenship, should be debated. Is that the point that you were trying to make? The reason is that if you think of the average person outside of this, if a child is born in Barbados, the child is registered as a Barbadian, well, their birth is registered, the child is a Barbadian citizen, and that is the end of the discussion. I think, so in that sense, I would suggest that we leave the provision as is, rather than open up the question of citizenship in the questions as to whether or not it benefits the child to be a citizen of Barbados. I would like some clarity as to where you were going with the point, but I do agree with the Minister that out of an abundance of caution, we should keep the provision general.
So the comment was made not with the intention of debating if you should or should not register the child. But it was noting that, or it seemed to suggest a situation where the decision on registering rests with the minister. And if a decision had to be made, then it be made in the best interest of the child. Because the way how it was read is in special circumstances. So as you indicated, on a regular circumstance, if someone is born in Barbados, they are automatically registered. But if there were some circumstance where a decision then had to be made, then it be made consistent with whatever is in other legislation or what that demands. So I'm hearing from the drafters the intent to keep it general so that you don't open the door for arguments, and I heard lawyers love arguments about if it is in the best interest or not in the best interest. But it was simply saying, if you have to make a decision, then make it consistent with what we see in other legislation.
Thank you for that.
You're fine. Okay, any further comments, queries for the BEC? Again, let me thank you for taking your time out to be part of this very important process of national development. And I'm confident that your 10 recommendations will be taken into consideration along with what we have discussed this morning, because you clearly came here with, to dissect most of the matters raised in section 4.3 of the Immigration Bill, section 5.1 of the Citizenship Bill, section 3.8 of the Citizenship Bill, and the data protection matter, I know, harmonize the data collection and sharing provisions of the Immigration Act. These are matters that have been discussed, and certainly when we meet as a committee to deliberate after the oral presentation, I am confident that all these matters will be taken into consideration. So yet again, I thank you on behalf of the Joint Select Committee and Parliament. Thank you.
And Chair, let me just express my thanks on behalf of the Council and the Executive of the BEC for the opportunity to appear here this morning. And first, we had the opportunity to submit in writing, but to have the opportunity this morning to appear in person and have this dialogue around our submissions. I am confident that this intervention, along with the many others that the committee has, will strengthen the end result, the bill that comes out of this process. So once again, thank you.
Thank you. Let's move swiftly along because we don't want to delay the process of members who have taken their time out to be here. Thank you. We now welcome the representatives from the Barbados Bar Association. So we ask that you invite the members of the Barbados Bar Association to join us here in the Senate chamber to address these matters pertaining to the two bills before us. Yes, please. And as soon as you finish. Okay, good morning, distinguished members of the Barbados Bar Association. Welcome to this sitting of the Joint Select Committee. So on behalf of the Joint Select Committee of Parliament, I extend a warm welcome and sincere appreciation of your presence here today to make your oral presentation on these two important bills, the Immigration Bill and the Citizenship Bill. The committee recognizes the important role that you play, the role of the legal profession in contributing to the development of sound legislation and public policy. And as practitioners and officers of the court, your knowledge, your experience, and your professional insights are invaluable in assisting us to examine the legal, the constitutional, and practical implications of the proposed measures under consideration. So the Immigration and the Citizenship Bill, as you know, addresses a matter of significant importance, touching on issues of rights and obligations, national identity, governance, national development, and the administration of law. You have 10 minutes to present to this committee, and I know lawyers, I know you make your money by talking. I'm on the other side, I make my money by implementing. As an engineer, I made my money by implementing. We want to get through the process today seamlessly, but again, I thank you for taking your time out. And before you speak, you introduce yourself, your name, because we're being streamed. And of course, you have a very large contingent who will be listening attentively, because you're representing a very important group of people to national development and also to communities and to the future generation of this country. And without further ado, I would hand the floor over to you. And as you speak, you introduce who you are, and let's get the process going. Yet again, once again, thank you for being here with us. Over to you.
Good morning, Chair, and to members of the committee. I'm Larry Smith. I am, for the moment, the president of the Barbados Bar Association. With me is Mr. Kashawn Wood, to my left, who is the Assistant Secretary to the Barbados Bar Association. To my right is Ms. Lynn Marie Simmons, who is a member of the bar, and she is the chairperson of the Legislative Reform Subcommittee of the Barbados Bar Association. Thank you for inviting us and having us here. We were told originally it was going to be 15 minutes, and I realized that you have chopped us by 1/3. And so Ms. Simmons will lead the charge, and I will chime in at a certain point. So thank you.
We are very flexible, and if that's what was told to you, I will give you the 15 minutes. That's fine.
Okay, being cognizant of the time constraints, I have prepared a document which I will read, which contains the salient points that we want to make in expansion of what we have already made on the first occasion that we presented before the committee. Firstly, we want to speak about the absence of an explanatory information regarding the legislative reform of the Immigration Act and the Citizenship Act. During our first appearance before the Joint Select Committee, the members of the Barbados Bar Association highlighted the absence of an accompanying policy document and/or explanatory memorandum which would serve to explain and contextualize the proposed legislative changes. The then chairperson, Ms. Marcia Cadell, MP, informed the sit-in that some of the proposals for reform had their genesis in the findings of the Barbados Population Commission, which issued a Barbados Population Policy document in 2024. The BBA wishes to highlight the following observations made by the BPC. Firstly, The legislation should extend the categories of persons entitled to citizenship and permanent residence, retain and encourage repatriation of Barbadians and stem the brain drain, and promote managed migration of persons who can bring capabilities and resources to invest in the future of Barbados and to contribute to areas of the economy where there are unmet labor and skill requirements. Such approaches would likely meet the immediate and medium-term labor force needs and increase the number of persons contributing to government revenue through direct and indirect taxation. Of great importance was the recommendation of the BPC for the formulation and implementation of a managed migration policy, which would support economic and labor market objectives. The BPC highlighted the importance of a policy specifying short and medium-term targets for increasing working age population, which can be adjusted having regard to the changing economic, social, and cultural profile of the country and its developmental objectives and opportunities based on a continuous assessment of the impact of migration. It is our submission that any sweeping changes to the Immigration Act and the Citizenship Act must be informed by a migration policy which incorporates the aforementioned objectives, together with empirical data. To the best of our information and knowledge, no such policy document exists, and we find ourselves in a cart before the horse scenario. The decline in population is not unique to Barbados. Last month, Patrice Quesada, I hope I pronounced his name correctly, the regional coordinator for the International Organization for Migration, observed that Caribbean nations faced with shrinking populations and growing labor shortages are reevaluating migration policies as a key pillar of economic survival. He said that declining demographics were affecting countries throughout the region, while labor shortages continue to place pressure on critical sectors like construction, healthcare, and tourism. Mr. Quesada specifically highlighted St. Lucia's national migration policy as a possible model for other Caribbean countries. I'm going to turn now and talk a little bit about the St. Lucian migration policy. On the 18th of May, 2026, with the support of the International Organization for Migration, the government of St. Lucia launched its draft migration policy, positioning our sister island as the leader in evidence-based, inclusive migration governance. That policy reflects a whole of government and a whole of society approach, grounded in data, stakeholder consultations, and a forward-looking vision that recognizes migration as a driver of sustainable development. At its core, the draft National Migration Policy seeks to ensure that migration in St. Lucia is effectively measured, monitored, and managed through a gender-sensitive, right-based, and development-oriented framework. It prioritizes key areas such as labor migration, diaspora engagement, data systems, protection of vulnerable groups, and migration governance in times of crisis, while promoting national resilience and inclusive growth. It is our submission that Barbados should adopt a similar exercise. In and of itself, the Barbados population policy falls short of the kind of content which is required to support and inform a whole of government and whole of society approach, grounded in data, stakeholder consultations, and a forward-looking vision that recognizes migration as a driver of sustainable development. I'm now going to turn to considerations for the work permit regime. It is further submitted that a piecemeal approach to policy making would be a significant misstep. For example, the people of Barbados have seen firsthand the effects of failing to employ data-driven analytics in government's approach in allowing foreign nationals to supplement the labor shortages in the construction sector. There are at least, I would say, 7 hotel, condominium projects in addition to those already under construction. These projects have resulted in a high demand for artisans and laborers who now command a premium for their wages. Developers and contractors have argued that the local labor force must be supplemented by foreign laborers, and that about 1,000 short-term work permits are urgently needed, with 100 more to be required in the coming months. At the same time, the Barbados Bar Association has also observed that one of the largest and long-standing construction companies will now have to retrench members of its staff, citing declining competitiveness and sustained operational challenges. At the heart of their retrenchment decision seems to be the fact that the company honors its NIS and PAYE obligations. However, it has been brought to the attention of the Barbados Bar Association that foreign imported laborers are treated by their local employers as quote-unquote independent contractors who are responsible for paying their own PAYE and NIS contributions, even though the facts are clear that the relationship is that of a contract of service, i.e. an employer and employee type relationship, not a contract for services, i.e. an independent contractor. It is our submission that the government should consider whether an employer who deliberately creates a category of worker with the label independent contractor, when all other criteria point to that person being an employee, is not offensive to the laws of Barbados. In particular, whether such a decision is, in effect, a fraud on the NISSS by denying that service the contributions to which it should properly be entitled. It is our submission that any forward-thinking legislation must seek to ensure and correct these anomalies and disparities. It is the understanding of the Barbados Bar Association that local construction companies and developers have called upon government, one, to design a scheme where construction workers can circumvent the established procedures for short-term work permits and have a fast-track route designed and implemented for the processing of short-term work permits for construction, and two, for the government to waive work permit fees. It is our view that neither of the two requests should be acceded to for the following reasons. The BBA has canvassed the views of attorneys who have handled bulk application for construction workers. Our inquiries have revealed that more often than not, amongst each group of applications presented to the Immigration Department for processing were persons who previously had criminal convictions. Every effort must be made to ensure that persons are properly vetted and screened by the Immigration Department prior to their arrival on island. We are also aware that a small group of foreign workers were recently brought into the island to work on a construction project, and they absconded from the project. Their employer was unaware of their location on island. Clearly, the current system of tracking foreign workers on island is flawed and must be urgently revisited with a view to strengthening it before any mass influx of workers. Construction workers are usually hired under a short-term work permit visa. This visa was developed for itinerant workers who generally fall outside of the tax and NIS nets. It cannot be that the government must be placed in a position where it can only benefit from indirect taxes, especially where concessions are granted to contractors and developers under the Tourism Development Act. The government fee for each short-term application is a mere $300, while the work permit fee per month for CARICOM workers starts at about $100 to $110. And for non-CARICOM workers, it's within the range of $210 and $300. This should not significantly erode the profit margin of developers. The implementation of any policy which would seek to marginalize the local workforce in favor of untested foreign workers would be socially unjust and politically problematic. The BBA is of the view that, in addition to the work permit fee being charged, that a flat fee should also be applied to each applicant, which would be seeded into the NIS scheme. Persons will only be able to access the NIS scheme once they have satisfied all of the criteria for assessing its benefits. However, foreign workers will still be required to contribute to the scheme. A similar type of system has been employed in other countries which are heavily reliant on labor forces, for example, the British Virgin Islands. In addition, employers of foreign nationals who hold short-term work permits should also, as a condition of that permit, be required to effect insurance in respect of their employees. It has been represented to the BBA, Barbados Bar Association, that the Immigration Department has stopped stamping the passports of foreign nationals entering the island. The Bar does not support that decision. We submit that this is a misstep since it is impossible to verify the length of time a permitted entrant has on island without reverting to the Immigration Department. There must be a simple way to verify whether or not a person is lawfully on island. In the past, this could easily be done by examining the passport for an entry stamp. I'm going to turn now to our president, who will deal with our additional comments. And I think we're still within time.
Yes, I believe we still have time, Chair.
Proceed. We like I said, we are very flexible. And
Okay.
you're
Thank you,
going
Chair.
well, so we'll give you that latitude.
Thank you, Chair. We want to address the issue of the economic citizenship. It has been the policy of successive governments that we do not support an economic citizenship position. As far back as 2009, Barbados does not subscribe to the concept of economic citizenship and pursues a policy of not granting such status to non-nationals in return for financial contributions or economic benefits. The legislation should therefore be amended to reflect this, and this was in 2009. The Barbados Bar Association, we recommend that the Barbados Citizenship Act should be amended to state that under no circumstances will such citizenship be granted. Similarly, the Caribbean Community Movement of Skilled Nationals Act 2004-13 should be amended to state that economic citizenship will not be recognized as part of the definition of national. The term economic citizenship should be defined in all relevant legislation, and that is certainly not the case in the bills that are being proposed. In December 2005, the European Commission signaled a hard line towards Caribbean citizenship by investment programs, stating that the existence of such programs in itself may now constitute grounds for suspending visa-free travel to sanctioned countries. In its 8th annual visa suspension mechanism report, Antigua and Barbuda, Dominica, Grenada, St. Kitts and Nevis, St. Lucia were identified as countries operating programs that pose a significant and ongoing challenge of a much greater scale than similar schemes in the European Union. Between them, the 5 countries have issued over 100,000 passports to individuals obtaining citizenship by investment. The Commission expressed particular concerns regarding the adequacy of security vetting procedures, citing a short vetting time and low rejection rates. In July 2023, the United Kingdom withdrew visa-free access for Dominica, citing clear abuse of its citizenship by investment programs, including cases where citizenship had been granted to individuals it regarded as security risks. Earlier this month, Ireland cut its visa-free access to St. Kitts, St. Lucia, and Nicaragua. The Department of Justice, Home Affairs and Migration in Ireland announced the change on the 11th of June 2026. So it is the Barbados Bar Association's position that, having regard to the free movement which exists between Dominica, St. Vincent and the Grenadines, Belize, and Barbados, with the possibility of more members joining the current group of 4 CARICOM countries, we endorse the 2009 Ministry of Labour and Immigration's recommendations to include a definition of the term economic citizenship in the bill before the House and exclude those individuals from becoming eligible for obtaining Barbados citizenship. We look at now the constitutional amendment issue. In 2019, the paper was brought to Cabinet for the approval of a revised Barbados immigration policy and proposals for legislative reform. Noting that both Chapter 2 of the Constitution of Barbados as well as the Barbados Citizenship Act, Cap 186, provide for the grant of citizenship. There were and still are inconsistencies between these two pieces of legislation, and they are in need of some kind of resolution. The bill and the two bills in their current format would leave the inconsistencies unaddressed. The paper proposed a number of constitutional amendments which would be required to harmonize the Constitution with the Citizenship Act. The Barbados Bar Association observes the absence of any bill containing proposed constitutional amendments. Certainly the bill in its current form does not indicate that it is an act to amend the Constitution, and therefore, as it currently is, it would therefore create issues. And should the tabled citizenship bill be passed without the requisite amendments to the Constitution, the government can well expect that there will be members of the bar filing with some level of haste constitutional motions to have the act struck down as being unconstitutional and in conflict with the supreme law of the land. Of some import and of great concern to the bar is the significant reduction of the days test for obtaining citizenship. Currently, a person who has been ordinarily resident in Barbados for not less than 7 years, that is approximately 2,555 days, of which an aggregate of not less than 5 years, approximately 1,825 days, must have been spent in Barbados, or for such shorter period as the minister may in special circumstances accept. That person can apply for citizenship under the Citizenship Act. Section 3.2 of the Constitution also provides grounds for the Commonwealth citizens who have been ordinarily resident in Barbados continuously for a period of 7 years, that is approximately 2,555 days, to apply for citizenship. Section 3A of the Constitution allows a person who has been ordinarily resident in Barbados throughout the period of 10 years, that is approximately 3,650 days, immediately preceding the application to apply for citizenship. In 2020, a proposal was made that Section 4 of the Citizenship Act be amended to allow for a person who was granted permanent residence under Section 5.2c of the Immigration Act and who had resided in Barbados for a total of 1,095 days, that is approximately 3 years, in aggregate during the last 6 years immediately preceding the date of application to be registered as a citizen of Barbados. Moreover, a person who was an immigrant for a period exceeding 5 years may, within 3 years after the commencement of the Act, make an application to the minister to be granted citizenship upon satisfying the minister that he or she has been an immigrant for a period exceeding 5 years. The Citizenship Bill 2006, Part 2, provides additional grounds of citizenship and registration of certain individuals as citizens. A person who is a national of a member state by birth, descent, or naturalization, their spouse and dependents, and who has resided in Barbados as a permanent resident for an aggregate of 180 days, that is approximately 6 months, during at least 730 days, which is approximately 2 years, immediately preceding the date of the application, or a non-national of a member state, their spouse and dependents, who have lawfully resided in Barbados as permanent residents for an aggregate period of at least 270 days, which is 9 months out of a period of 1,095 days, approximately 3 years preceding the date of application. And here is some concerns for the members of the bar. So for example, there are 4 member states now for which there's free movement. I can leave here, go to Belize, Dominica, St. Vincent and the Grenadines, and turn up, register, work, reside without any issues whatsoever. So we know Dominica has a citizenship by investment program. So someone through financial investment in Dominica becomes a citizen within, 3 months, 4 months. They're now a citizen of a member state. And not just a member state of CARICOM, they're now a citizen of a member state for which he or she can move freely. So they come to Barbados after 4 months, can set up here and work and live as currently the relationship is between these 4 territories. And then within 6 months, they can apply to become a citizen of Barbados. So someone has, within 10 months, become a citizen of 2 CARICOM member states. Where is the vetting process? How is the vetting taking place? How are we securing the borders? How are we being assured that the individual or individuals are the kinds of individuals that we want to attract to address the issues of the population shortage in this country? So, and they've spent 6 months out of 2 years. So if they come here and they're here for 6 months, 6 months continuously, spend 6 months, then they qualify out of the 2 years. So that it should be noted as well that there is no definition of ordinary resident in any of the 2 bills before being considered. The Barbados Bar Association of the view that a definition of the term ordinarily resident along the terms as stated in the 2019 Cabinet paper should be included in Section 2 of the bill. Ordinarily resident means the lawful residence in Barbados for no less than an aggregate of more than 132 days per year. And that is the definition found in the Income Tax Act. We have not seen yet any policy document that underpins any of the bills. So we're not sure if they exist, but certainly at the level of the bar, we have not seen any policy document, as has occurred in St. Lucia, which is the driving force for their immigration act, their policy. The CBC, nothing which indicates via empirical data, via any form of substantive discussions, why there should be a truncation of the qualification periods. And so it is the position of the Barbados Bar Association that we strongly oppose the truncation of the days test as proposed under the current bill. We are available for questions from the committee. I know that it was raised previously, if I may, with your leave, Chair. The question was asked, why are we moving with such haste to address, to deal with these bills? And haste is useful. I believe the minister at the time, Senator Nichols, senior minister, indicated that, as reported in the press, that some people had waited years. I think it's a question that was raised by Senator Malalu. And according to the newspaper report, it was suggested that some people had waited for years to get citizenship approved, and some died without ever hearing from the Immigration Department. And the minister, the senator, senior minister asked whether we were making some more wait longer than a Barbadian. Those of us who practice at the bar, and I see some of you here on this committee, would know that people have died waiting to have their probate and estate applications addressed at the registry of the Supreme Court. We would like the similar level of alacrity to attend addressing that issue at the bar, for the bar and for its members and for our clients who have died waiting to have their probate applications addressed. And so if dying becomes the issue, dying while waiting, then it is the bar's position that there are a number of other areas that directly impact the membership of the bar, where people dying before those issues are resolved, that we should be grateful to see that kind of attention being focused in that direction. Great to hear that. And of course, it is not simply for the members of the bar, but it is for the people we serve who are members of the public. We are grateful to you.
Thank you, Mr. Smith, Ms. Simmons, and Mr. Wood. On behalf of the Joint Select Committee, indeed, you've given us not only an earful, but you've given us some very important matters of national interest that we need to respond to. and incorporate into both bills before this joint select committee. But before I give way to the members, because I know the members, we would really love, because we have some other members here, some ministers. I heard you referencing senior minister, but he's not here. He's not privy to this document because we received it this morning. Sure. And in all fairness to the committee members, we will want to have this document circulated to all members. That's the protocol, so they too can be au fait with all of the matters raised. There's some very important matters, I must say to you, well articulated, and I didn't expect anything different from you all, the panel that is here. But I want the ministers especially who are not here this morning. Three ministers are absent from the committee, and you, the senior minister, he has probably heard you, and he'll want to respond to your queries and your submissions before this committee. And nevertheless, I would not say, and I speak on behalf of the committee, we will have a discussion this morning, but it would not be a final discussion on the matters raised this morning by the Bar Association. We have here the Minister, Minister Nichols, who's really the substantive minister as it relates to these two pieces of legislation. And of course, he would want to weigh. But I don't want to defend anybody. That's not my role. But I heard the last reference to the newspaper article, and we have to be mindful. You know, sometimes when we get third-hand news, it is not really, I would want us to refer to because it's being streamed, and we can refer to the live broadcast to get the true comments that were indeed raised in this. So that's why we're streaming. So the information is not distorted. And I'm not saying that the newspaper will distort the information. Don't take that from here. This being streamed as well. I never said that, but I will want you to reference the live broadcast on the day that the minister made his comment, in all fairness to him. And I think he was using it as an example as to why we have moved with alacrity, because the population policy that was revised in 2024 by the Population Commission is indeed a very critical document, as well as the BERT program that has informed how we have drafted these bills. And from a policy perspective, I don't want to speak on behalf of the minister, but just to say that when you refer to the population policy document and you see what our challenges are, then you will see why the committee, why the members of the committee, they have gone for a 3-year citizenship push and a 2-year citizenship push, because we have a crisis on our hand. Not just a problem, but a crisis. And I would pause there and allow the other members. I don't want to quote what I quoted 2 weeks ago, but I want to have frank discussion and fair discussion, and not to be biased as the chairman to anything that was presented here this morning. So I hand over to the members of the committee for their comments. And again, thank you for such an expansive and detailed presentation. So over to you, members.
Grateful to you, sir.
Senator Malago.
Thank you, Chair, and thank you to the members of the bar who have presented this. I would like to start with perhaps a little clarification, because I have my own notes with regards and my own challenges. You correctly quoted me on what I think we're doing in here in terms of opening a back door for citizenship from the CARICOM free movement areas. You actually quoted a 3-month time, but I want to be clear on Dominica, which is part of our CARICOM free movement. There is absolutely no requirement to ever visit Dominica at all to get your citizenship. If you read what is on there, you can apply from overseas, you can make your investment from overseas, and you can receive your citizenship from overseas. So when we look at those timelines, I'm in support of what you're saying, the backdoor that has troubled me with this is that you can have someone who receives a citizenship in Dominica, because at present there are only 4 countries that are participants of that, which are Dominica, St. Vincent, Belize, and Barbados, and the only one with a CBI program is Dominica. But in that same bill, those countries can be expanded at the minister's discretion. It does not need to come back at all to Parliament for the countries to be expanded. Any CARICOM country can be added to that list at any point in time, and there are many CARICOM countries with CBI programs. But the question I wanted to ask you, because I just didn't only want to agree with you, but I wanted to get your advice and your learned counsel on this, is that I've been told whenever I raise this, is that it would be a problem, it would be wrong, it would be, in some ways almost told me it's unconstitutional to look through a CARICOM national's passport and ask the question, how did you come to have this? And I would like to know from you if you feel that there is anything in law or there's any reason why as an independent republic we could not build into this bill our own right to look through the passport that you're presenting to us and say, how did you come to be this? And if you are a CBI, if you have come to this passport by a citizenship by investment program where you have had absolutely no requirement ever to integrate into CARICOM in any way whatsoever, you have paid your money to another country, that gives you the right to reside, work here, and after 6 months, you would be eligible for a passport. Is there any reason that you would know as lawyers as to why we could not do that?
I would suggest that we revert to the position which was contained in the 2009 Green Paper, which we spoke about earlier today, that mischief can be simply solved by excluding economic citizens and including in the legislation a definition for economic citizens. That strikes at the heart of citizenship is something, and I spoke about it last time when I was here. You should have a very close and real and abiding connection with the country with which you want to become a citizen. Because you have bought citizenship, that almost seems repugnant. So it would be my suggestion that on that basis, that you include a definition for economic citizenship, and that way you can exclude those persons from being eligible. And if you want to have a halfway mark, you can probably say they would have to spend a longer period of time, say 5 years, and they need to spend time here. They need to invest in businesses here. They need to integrate within society before they can be elevated to the level of citizenship. And let us not forget that we have a common experience with our Caribbean nations. So we can understand the thinking behind treating other born CARICOM nationals differerly, because we're very similar between the islands. But that is not the case if you have somebody from some far-flung part of the world that has a lot of money that says, I want to be a citizen. They have no idea what we're about. They haven't actually lived, breathed, worked, integrated into society. So as a policy, I don't see any problem with ring-fencing that particular category of person. I understand that to be a devil's advocate, people can say, but isn't it discriminatory? Aren't you discriminating against a particular class of person? But we must be able to form a policy that works for our country and that protects the value of our passport and does not seek to devalue our citizenship or our ranking, our passport ranking globally.
Through you again, Chair. Thank you for that response. It's the same conclusion that I had reached. There would be no reason why not to do it. In fact, in looking further at the Dominica example, just to play this out, and when we refer to wealthy people, I want to say $200,000 US in terms of global wealth these days is not a high bar, especially when that fee could have actually been paid on a parcel of real estate, which according to Dominica law, you can sell within 3 years. So really and truly, you only need to hold the real estate in Dominica for 3 years. During that 3 years, you would have resided in Barbados for 6 months. You would have ended up holding a Barbados passport, and you can dispose of your Dominica real estate at any point you would like. I would say that I am more inclined, and I would just I would end on this and maybe get your comments on it. Is I'm more inclined to treat people who have received their nationality through through the CBI program, one with enhanced due diligence, because I do not think that we can rely on other islands, other member states to do the level of due diligence that we might want, and I don't think that we should give that up as part of our sovereignty when we talk about the national security risks. I don't think we should be subordinating that to someone else. We should have enhanced due diligence for CBI applicants. And then I would agree with you that I think that the residence period should be extended for those who are not already integrated within CARICOM through their birth or through by descent or what other way. And that type of an amendment would more likely get my favor than one that simply as it is written now, which I think is too easy. So, Mr. Chairman, those are my comments, but I'm happy to hear anything that's on it.
Thank you, Senator Malolo. And over to you, Minister. You've heard the submission, and I would want you to weigh in at this time.
Thank you, Mr. Chair. Let me first of all thank the Bar Association for making this new presentation before the committee. I haven't had sight of it until just now, so I am not going to respond to this submission, which I only just received. But it raised a number of important issues, and certainly will give the committee the assurance that the ministry and the government will respond to this so that the committee will have the benefit of the government's position as it deliberates the submissions made by the bar. One of the difficulties that you have in this exercise is because there was a composite debate of both the citizenship bill and the immigration bill before Parliament was dissolved, and when I laid the bills recently in the House. There seems to be in the public debate and discussion a conflation of things, and that is what I was here discussing with the Chief Immigration Officer, because there's an abolition of the category of immigrant status in the immigration bill, and because of that, a number of transitional things had to be written into the legislation, because we're no longer going to have that intermediary category of permanent resident, immigrant, citizen. There's now a proposal for either citizen or permanent resident within the context of Barbados in our immigration legislation. But in order to become a citizen of Barbados, you're either born in Barbados, you're either a descendant of a Barbadian, or you can be a permanent resident who is applying. And the application of the permanent resident must require that person to become a permanent resident within the Immigration Act before they can, as a permanent resident, apply to be a Barbadian citizen under the Citizenship Act. So the two periods have to be combined. So what you have is that some people are looking at the time period within the Citizenship Act and making it seem as if that is the only period which the application is being considered, and not the length of time that they would have had to be a permanent resident. And also, prior to that, qualifying to be a permanent resident would of necessity require you to be resident in Barbados for a period of time within the context of the Immigration Act. So I wanted to thank the bar for these submissions, and certainly this is what I think is valuable exercise in terms of how the government sees legislation through the process by way of engaging the Joint Select Committee and members of the public for contributing to the substance of the legislation. A lot of important points are made here. I am not surprised at the level of scholarship and research that has gone here, and because I do associate myself with the members of the bar. I'm still a member of the bar for all intents and purposes, and I know each of the members who are preparing for the committee, Mr. Chairman, very, very well. So I'm not surprised at their contribution, but I will take the opportunity to request time to study and consider these submissions and to make a substantive reply to the bar's position. Thank you, Mr. Chair.
Thank you, Minister Nichols, and I think that's only fair, especially to the other members who are not here as well, so we can have a fair and frank discussion to impact these two pieces of legislation in a meaningful way. Senator Walters, and then I'll come back to you, Mrs. Smith.
Thank you, Mr. Chair. I think it is, I think what the Minister has put forward seems fair, but I think that we should give the bar, representatives from the bar, opportunity to come back to have the discussion, and not necessarily the government just placing a response to these issues, because all the other contributors were given the opportunity to have dialogue on different points. And I wouldn't want that we or the government takes a position where they look at the points and they send back some notes or make a couple political points, but they give the Bar Association an opportunity to engage in the discussion if they're so willing on the points that they have raised, and then the feedback from the government side. To me, it's only fair that that happens in this situation, if they're so obliged to do.
Mr. Chairman, I say I am in no way shying away from the opportunity to have a discussion with my colleagues. They will tell you that I've had discussion on their previous submissions extensively with Mr. Simmons, and I spoke when I was a member of the Joint Select Committee on Governance Policy. We had a substantial decision on that report, and as I did with both the Secretary and the President of the Bar. So I didn't want it to seem like I'm going to come back in their absence, because I'm willing to have that discussion. Yeah.
And I heard you, Senator Walters, and while I agree that we should have dialogue and not just send back comments to the Bar Association, we are still operating within a specific time frame and guidelines as a committee, and this bill has to get before the chamber, the lower chamber, within a very short time frame. So it's my wish that, you know, we don't have another sitting where key members are not present, because while I don't want to belabor the point, I would have preferred to have even one night to sit down to make comments and notes and call the various members to find out a few things on it, but we were not given that opportunity either. So while I hear you, Senator Walters, you're not saying this for the first time as well. And I don't think you're in a position, neither of us, to really have the comments that we had with the other members, because we had those presentations before us, and we were able to have open and frank discussion on them. So the bill, we'll revert if there are no other comments for sure coming from the members or other members you wish to comment on. CPC, I know you're here, and this food for thought. I know you want to endorse and then come back as well. Minister Springer, you're fine. Chief Immigration Officer, I see there are some comments that you have stopped. This stamping of is a direct statement there. But you can comment there if you security, because there are some things that were said, and we have the parties here who can comment. And I think there is a section in here, if I listen attentively, I'm trying to find the page. Could you guide me, Ms. Simmons, where you said that the Immigration Department refused, stop stamping, not refused, they stopped stamping
That's in the,
passports? That's a section, I recall you.
Ms. Innes is here and she can possibly speak to that.
Yeah, but which section it is, that's what
It's
we're
under-
asking, because we're now seeing it for the first, and so guide us, please. But I recall you saying that it jumped out at me. Page 10.6 is being represented to the Barbados Bar Association that the Immigration Department has stopped stamping the passport of foreign nationals entering the island. The BBA does not support that decision. It is a misstep since it's impossible to verify the land. And this was under the context of employment, I think this is.
So we can draw a difference between somebody coming into Barbados at the port of entry. Your passport is not stamped there. It is only stamped if you submit it to the department for endorsement. And some occasions that doesn't happen. So procedurally what happens, you apply for a work permit, you get a request for the payment of the fee if it's been approved. You pay the fee, then after about a couple of weeks, you will then get another letter saying you have been granted the work permit from this date to this date, and you can submit your passport to the department for endorsement. And at that stage, it gets stamped with the duration of your work permit. More often than not, persons don't submit their passports to the department for endorsement, and therein lies the problem. Because on the face of it, you wouldn't be able to see if you've come into Barbados and I ask you to show me your passport and how long you're here for and what is the period of stay granted, unless it's been endorsed or unless you're walking around with your approval letter, you're not going to see it on the passport.
Margaret Ennis, Chief Immigration Officer. Limery, I totally get where you are coming from. But I will also add that given that the Barbados Immigration Department is one of 7 identified for digital transformation, you can appreciate that we are moving away from the paper-based to a digital system where you're not stamped, one, at the airport, because we've had several of our valued customers coming in and saying, I travel here so often that my pages are being exhausted. So Barbados took, I believe, a policy decision in keeping with the rest of the world, or for most parts of it, that we're not going to stamp. However, in our system, you are within the system, and if immigration needs to know something, they'll go in the system to find out whether or not you have been granted time, what time you have, whether it is just an entry visa or you have some form of status. As you know, there are many times when different agencies would ask for information, or let me say it this way, a person might ask for their information because they lose their passport and they want to get information, and that information is provided.
So you would still have to revert to the Immigration Department, is the point that we were trying to get across.
You revert to the Immigration Department because, as you can appreciate, we are evolving and we're taking steps, and we're going to get to that place where we have actually a system where you can actually, but that's in keeping with best practice, where you can actually go in and retrieve that information.
So, if I may, Chair, so I think the question that would concern us then is that in the interim, while we are evolving to a more digitized platform, what measures are in place to safeguard the borders of the country in the interim while we are evolving? That would be a concern.
Mr. Chairman, if you permit to answer that, the purple stamp on the passport does not secure the borders. The information that is within the immigration system is information that, and I don't want to get into too much of the sources and methods, but what I will say is that quite very shortly, legislation will be coming to Parliament to establish the framework for advanced passenger information and passenger name records, a new piece of legislation. Right now, Barbados operates on the basis of with CARICOM impacts, a system. We are going to be beefing up that and the legislative framework to deal with advanced passenger information, which we have access to now, but now adding passenger name record, which would also allow the state of Barbados and the competent authorities within the state to be able to manage that information prior to any vessel, aircraft, or any other vehicle coming into the country. It is not secured at the level of the RSS or CARICOM impacts by the purple stamp on the page. So this idea that not stamping a passport makes Barbados less secure as a place is I like to scotch that as it is right now.
Margaret Ennis again, Chief Immigration Officer. The absence of legislative underpinning of the special entry permit.
Yes, Ms. Innes, we dealt with that on the first occasion, but I'm happy to answer any questions because we made some oral comments and I had undertaken to reduce them into writing because we know that this committee is newly constituted and may not have had the benefit of hearing us on the first occasion. So that's just for information purposes, but if you want to ask me questions about it, by all means, I'm here to answer them.
Chair, through you, sorry, what I would say is, just for the benefit of the bar, the previous submissions were given to this committee. All the previous submissions were handed over to us. But it would be helpful to me if there's anything in particular about that special entry that the bar wanted to raise. I would have liked to have heard from it, and if you would allow them to tell us what the headlines of that was, or do it on the next occasion, I don't mind.
Certainly, Senator Malou. Before, I just want to hear from Chief Immigration Officer, and then we allow Ms. Ennis to share with us her recommendations on the subject matter from the previous, from the previous submission.
Thanks, Chair. The comments, I know you said about the special entry permit and you're going to beef that out and write in. Anything specific about the welcome stampers that we can discuss, or that was just a comment about welcome stampers having work permits?
Oh, the conversion from welcome
Yes.
status to work permits. Yeah, we had discussed that when we were formulating the legislation for that product, if you remember.
Of course.
So at that time, we had thought that if you came to Barbados during the pandemic and you were here for 6 months and you fell in love with the country and you wanted to not just work remotely, but you wanted to come here and start businesses and invest more substantially in the country, that what would be the quickest way for you to transition away from the remote work visa, which means that you don't work for an employer in Barbados who work overseas, who pay taxes overseas, to one that is working in Barbados, that is paying taxes in Barbados, that is paying NIS in Barbados. And we thought the quickest way to do that is to convert them using the short-term work permit. And we can still look at that now because there should be a mechanism where the information is given at the outset when somebody applies for the welcome stamp, and then that can be used to inform an application for a work permit should they decide that they want to work in Barbados, not just from Barbados.
Chair, we have persons who've been here for what, some 6 years? Yeah, 2020, under the Barbados Welcome Stamp. I am sure those persons are persons with specific skill sets that could definitely benefit the economy. And you're going to continue, or I'm going to finish? Yeah. Yeah, and I'm thinking that perhaps one of the considerations could be for them to roll over in the normal system of acquiring some form of status. They were those persons who assisted us at a time when there was no economic activity. And I remember specifically that there was a lot of discussion in terms of how we could fit them into our economy based on the skill sets and the fact that they made Barbados a choice place at a time when persons were running from place to place and they saw Barbados as that safe haven. So I think it's those kind of considerations, and given the fact that it's now been 6 years, and you and I know that we worked on making that a reality, so.
Chair, through to you. I like the 6-year number because automatically when you have a person that has been on a work permit for 6 years, the next step up is immigrant status under the current legislation. So in that scenario, we can look at Section 6 of the current Immigration Act, and see if an application for immigrant status cannot be grounded based on their skill sets and the potential for them to establish themselves successfully in Barbados in a profession, trade, business, or agricultural enterprise. It would be a policy consideration because those persons would not have been contributing directly into the tax pool. It would be through indirect taxation. But it is something that the minister should consider, and probably you can craft a policy behind that. So, and it's always better to give persons more than one avenue to establish themselves in Barbados.
Currently, the view is that there's more than one avenue. The avenues under the Immigration Act, and then the policy created by the Welcome Stamp itself. The bill that is proposed does not create the Welcome Stamp category as a basis for persons to come into the country under that, because that's under a different legislative regime altogether. And because of the special nature of that regime and its importance to Barbados at the time, and I do believe it has exceeded the original expectations and the way it is currently performing, there's active consideration as to if we can bring it within the context of the regime, or to let it stand alone as a regime managed by the Immigration Department on its own legislative footing. But that is actively being considered.
If I know, Mr. Smith, you wanted to.
Yes, before Senator Walters had asked that for us to come back, I had conferred with my colleagues, and we have all agreed that we are prepared to come back if the committee wants us to come back, and we're prepared to do so at short notice. We heard the comments of you, Chair, that there are some time constraints and some considerations. From the bar's perspective, certainly we just want to make sure that that whatever legislative framework is put in place, that it is on sound footing, it is solid, and it's something which perhaps is not susceptible to any extensive kind of legal challenge. So that is our role here part of our role to assist or to put forward the proposals of the bar or the suggestions of the bar. So while we understand the need for haste, we would still want to have an input, if allowed, if invited, and to not let haste be a factor for not ensuring that we get it right. I'm reminded that of a guy down at the psychiatric hospital who once said, "A hasty bird flies past the nest." So we want to not rush from the bar's perspective, but we know that government has this policy mandate or what it wants to do, and we're here to support and assist in any way that we can. So we thank you.
Thank you, Mrs. Smith, and thank you, Ms. Simmons and Mr. Wood. We certainly will get back to you on the appropriate timing. We in no way want to exclude you from the comments that will come from your presentation to us this morning that will inform this bill. I was just making the point that what we do, we have to do within a short time frame, and I am happy that you're willing to return in that time frame to assist us in ensuring that we get the best bills to the public for nation building, for our communities, and for a future generation. So we'll be communicating with you within a few days as to the best or the most appropriate time, not the best, the most appropriate time to return to the chamber so we can have discussion, of course, after our minister would have reviewed in its entirety and the other members of the team. And certainly I look forward again to having you here. And thank you again on behalf of the committee for your submissions. They're really indeed invaluable to this process. I thank you.
Thank you, Chair. Good day to all.
Members of the bar, Ms. Smith, Mr. Smith, Ms. Simmons, Mr. Wood, we invite you to stay. We'll have lunch shortly, so we invite you to stay for lunch with us. Thank you, sir. We can stop streaming at this stage because we're through with our presentations. It's just a matter of some housekeeping. So thank you, members of the Parliament, those who have been with us for the last 3 weeks, assisting the public in seeing the and the level of transparency that has gone into this process. So I thank you all.